Safety and health. Safety involves protecting employees from injury caused by work-related accident. Health refers to the employee's freedom from physical or emotional illness. History of health and safety at work in Malaysia. The Occupational Safety and Health Act 1994 or Act 514 provides the legislative framework for the safety, health and welfare among all Malaysian workforces. The principle is to prevent and protect the workers against hazards and its risks in connection with their activities at work. It requires all companies to establish and document 1. Safety and health policy. 2. Duties of the employer, employees and the safety and health officer. 3. The safety and health committee of companies. And 4. The occupational safety and health inspector and officer. Section 16 requires the employer to formulate safety and health policy at the workplace and regularly revise the policy to align the policies with changes and best practice in the business world. Safety and health policy is to demonstrate the company's commitment and concern to ensure safety and health at place of work. Issues on safety and health stated in the policy must be taken into account. What is Occupational Safety and Health Act? The Occupational Safety and Health Act is an act which provides the legislative framework to secure the safety, health and welfare among all Malaysian workforce and to protect others against risks to safety or health in connection with the activities of person at work. This act was gazetted on 24 February 1994 and may be cited as the Occupational Safety and Health Act 1994. This act is a practical tool superimposed on existing safety and health legislation. There is 4 aims of this act, which are 1. To secure the safety, health and welfare of persons at work against risks to safety or health arising out of the activities of persons at work. 2. To protect persons at a place of work other than persons at work against risks to safety or health arising out of the activities of persons at work. 3. To promote an occupational environment for persons at work which is adapted to their physiology and physiology needs. 4. To provide the means whereby the associated occupational safety and health legislation may be progressively replaced by a system of regulation and approved industry codes of practice operating in combination with the provisions of this act designed to maintain or improve the standards of safety and health. Concept of self-regulation. The provision of the Occupational Safety and Health Act 1994 are based on the safe regulation scheme. Its primary responsibility is to 1. Ensure safety and health of work lies with those who create the risk, and 2. Those who work with the risk. Through self-regulating scheme that is designed to suit the particular industry or organization. This act also aims to establish effective safety and health organization and performance. The concept of self-regulation encourages cooperation, consultation, and participation of employees and management in efforts to upgrade the standards of safety and health at the workplace. Role of authority. The Occupational Safety and Health Act 1994 is enforced by the Department of Occupational Safety and Health, or DOSH, a government department under the Ministry of Human Resources Malaysia. Department of Occupational Safety and Health, or DOSH, a government department under the Ministry of Human Resources Malaysia, is responsible for through enforcement and promotional works to employer, self-employed person, manufacturer, designer, importers, suppliers, and employees to always practice safe and hard work culture and always comply with the existing legislation, guidelines, and codes of practice in relation to occupational safety and health. Department of Occupational Safety and Health, or DOSH, will also formulate and review legislation, policies, guidelines, and codes of practice pertaining to occupational safety, health, and welfare as a basis in ensuring safety and health at work. Department of Occupational Safety and Health, or DOSH, also is the Secretariat to National Council for Occupational Safety and Health, a council established under Section 8 of the Occupational Safety and Health Act 1994. The National Council for Occupational Safety and Health shall have power to do all things expedient or reasonably necessary for or incidental to the carrying out of the object of this Act. Implementation of Department of Occupational Safety and Health, or DOSH. 1. All employers with more than 5 employees are required by the legislation to arrange a written safety and health policy. The objective is to demonstrate the commitment of the employer or company to ensure safety and health in the workplace. 2. Safety and health policy must be taken into account when making decisions or performing work activities of the organization. 3. This law also specifies the general duties of employers, self-employed person, manufacturer, designer and suppliers, employees, the establishment of the Safety and Health Committee, the appointment of a Safety and Health Officer, and the enforcement, investigation, and officers. Occupational Safety and Health Committee Regulations 1996. There is 6-part arrangement of regulation, which is Part 1, Preliminary, Part 2, Composition of Safety and Health Committee, Part 3, Functions of Safety and Health Committee, Part 4, Meetings of Safety and Health Committee, Part 5, Provisions of Training and Information, Part 6, Penalty. Part 1, Preliminary. 1. Citation and commencement. This regulation may be cited as the Occupational Safety and Health Committee Regulation 1996 and shall come into force on 1 January 1997. 2. interpretation. In this regulation, unless the context otherwise requires, authorized manager means a person duly authorized by an employer to deal with any matter relating to the safety and health of person employed at the place of work. Chairman means the chairman of a safety and health committee. Director General means the Director General of Occupational Safety and Health appointed under subsection 5(1) of the Act. Member means a member of a safety and health committee. Near miss accident means any accident at a place of work which has the potential of causing injury to any person or damage to any property. Safety audits mean the safety and health audits of plan and system of work to ensure the safety and health of person employed at a place of work. Safety and health auditors means person whether employed at a place of work or otherwise appointed by the employer to conduct safety audits at the place of work. Secretary means the secretary of a safety and health committee. 3. Application. This regulation shall apply to a safety and health committee established under section 30 of the Act. A safety and health committee formed at a place of work before the commencement of this regulation shall reorganize itself in accordance with this regulation within 6 months from the date of the commencement of these regulations. 4. Duties of employer. It shall be duty of an employer A. To comply with parts 2 and 3 of this regulation, and B. To ensure that parts 4 and 5 of this regulation are complied with. Part 2. Composition of Safety and Health Committee. 5. Membership of Committee. 1. A Safety and Health Committee shall consist of A. A chairman, a secretary, representative of employer, and representative of employees. 2. Where there are 100% or less employed at a place of work, there shall not be less than 2 representatives each from the employees and the management on the committee. And where there are more than 100% employed at a place of work, there shall not be less than 4 representatives each from the employees and the management. Number 6. Appointment of Chairman and Secretary Committee. 1. An employer or his authorized manager shall be the chairman of a Safety and Health Committee. 2. The secretary of the committee shall be the person who is employed as the safety and health officer at the place of work. 3. Where there is no person employed as a safety and health officer at the place of work, the chairman may appoint another person to act as a secretary of the committee, or the members may by ballot appoint from amongst themselves the secretary of the committee. Number 7. Appointment of other members of committee. An employer shall invite persons employed at the place of work to nominate their representative to the Safety and Health Committee, and where the number of persons so nominate exceeds the number of vacancies available, a ballot shall be held to determine the representative. In the case where no representative or an insufficient number of representatives of an insufficient number of the representatives of the employees are nominated, the employer shall appoint the required number of persons to represent the employees in compliance with Regulation 5. An employer shall not penalize a member of the committee in any manner for being absent from his normal duty at work while carrying out the function of the committee. Number 8. Adequate employee representing. The representative of employees in a safety and health committee shall be able to represent the various sections of a place of work in order to maintain and develop the employees' interest in establishing a safe and healthy working condition at the place of work. Number 9. Vacancy. If a vacancy occurs amongst the members of a safety and health committee, the vacancy shall be filled by a person appointed in the same manner as the previous member of the committee whose resignation or otherwise has created the vacancy. Number 10. Removal of member or committee. A safety and health committee may remove a member from the committee if A. He fails to attend 3 consecutive meetings of the committee without leave of the chairman. B. He has been found or declared to be of unsound mind. C. He becomes bankrupt. As a representative of employee, he is no longer employed at the place of work. E. There has been proof against him or he has been convicted on a charge in respect of 1. An offence involving fraud, dishonesty or moral turpitude. 2. An offence under a law relating to occupational safety and health. Or 3. Any other criminal offence. And F. He is otherwise unable or incapable of discharging his duty as a member of the committee. Part 3. Functions of Safety and Health Committee. Number 11. Functions of committee. The Safety and Health Committee of a place of work shall A. Assist in development of safety and health rules and safe system of work. B. Review the effectiveness of safety and health programs. C. Carry out study on the trends of accident, near-miss accident, dangerous occurrence, occupational poisoning or occupational disease which occurs at the place of work, and shall report to the employer of any unsafe or unhealthy condition or practice at the place of work together with recommendation for corrective action. And D. Review the safety and health policy at the place of work and make recommendation to the employer for any revision of such policies. Number 12. Inspection of place of work. A safety and health committee. A. Inspect the place of work at least once in every 3 months to ascertain if there is any prejudicial to the safety and health of person employed therein, provided that the committee may at any time make further inspection of any plant therein or any part of the place of work to check on the effectiveness of the measure taken to ensure the safety and health of person at the place of work. B. Discuss as soon as is practicable the observation of the members of the committee made during the inspection of the place of work, and if there are circumstances at the place of work which, in the opinion of the committee, are prejudicial to the safety and health of any person employed therein, shall record the details of such circumstance in a report kept for such purpose. And C. Make recommendation to the employer on the remedial measures to be taken on any matter prejudicial to the safety and health of person at the place of work, and shall record such recommendations in the report. Number 13. Investigation into any accident. 1. A safety and health committee shall inspect the place of work as soon as it is safe to do so. After any accident, near-miss accident, dangerous occurrence, occupational poisoning or occupational disease has occurred at the place of work. Number 2. Where a person is employed as a safety and health officer, he shall furnish the chairman of the committee with a report of his findings subsequent to an investigation conducted by him into an accident, near-miss accident, dangerous occurrence, occupational poisoning or occupational disease which has occurred at the place of work, and the chairman shall, as soon as it is practicable, convene a meeting of the committee to discuss the report. 3. Where no safety and health officer is employed at the place of work, the employer of or his authorized manager shall forthwith inform the chairman of the secretary of the committee of any accident, near-miss accident, dangerous occurrence, occupational poisoning or occupational disease which has occurred at the place of work, and the chairman of the secretary shall, as soon as is practicable after the committee has inspected the place of work, convene a meeting to investigate into such accident. 4. At the meeting of the committee convened under sub-regulation 2 or 3, the committee shall discuss the cause of the accident, near-miss accident, dangerous occurrence, occupational poisoning or occupational disease, and make recommendation to the employer of the measures to be taken to prevent the reoccurrence of such incident. Number 14. Action to be taken or report and recommendation of committee. 1. A safety and health officer, or if no person is appointed as such, the chairman shall, upon a report or recommendation being made under paragraph 12C or sub-regulation 13(4), furnish the same to the employer or his authorized manager. 2. An employer or his authorized manager shall, as soon as is practicable upon receiving the report or recommendation under sub-regulation 1, discuss the report or recommendation with the safety and health officer or the chairman, as the case may be, and the safety and health officer or the chairman shall record in the report the employer's or his authorized manager decision thereon, and shall direct any person employed at the place of work to take such action as the employer or his authorized manager deems necessary in the interest of the safety and health of person employed therein. 3. An employer shall keep a copy of the report in the place of work for a minimum period of 7 years. 15. Matters to be considered by committee. A safety and health committee, when performing its functions, shall take into consideration the following. A. Any other reports apart from those under Regulation 14 which may be submitted by a safety and health officer. B. The safety audits submitted by safety and health auditors. C. The reports and factual information provided by occupational safety and health officer. And D. The report by other government agency on matters pertaining to safety and health at a place of work. 16. Investigation of complaint. 1. An employer shall provide and maintain a system of communication to enable any of his employees to make a complaint on any matter prejudicial to the safety and health of person at the place of work. 2. An employer, upon receiving a complaint under sub-regulation 1, shall, as soon as it practicable, attend to the complaint and shall take immediate measures to eliminate or minimize the risk to safety and health at the place of work. 3. Where an employer is unable to discharge his duty under sub-regulation 2. The employee may make a similar complaint or the employee may refer the matter to the committee. 4. The committee shall, upon a complaint being made or matter being referred to under sub-regulation 3, investigate the matter and shall thereafter prepare a report and make recommendations to the employer on the ways of eliminating or minimizing the risk to safety and health at the place of work. Number 17. Resolution of complaint. 1. An employer shall, as soon as it practicable, implement every recommendation made under sub-regulation 16.4, and if for any reason he or his authorized manager is unable to implement any of the recommendations, he shall convey his reason to the Safety and Health Committee. 2. If the committee does not agree with any of the reasons given by the employee or his authorized manager under sub-regulation 1, the committee shall make a request to the Director General to undertake an inspection of the place of work and to resolve the matter. 3. For purpose of a request made under sub-regulation 2, the committee shall submit to the Director General in duplicate the following: A. The inspection or investigation report, B. The recommendation of the committee to the employer, and C. Any other documentary or material evidence pertaining to the complaint. Number 18. Assistance of committee. A safety and health committee shall assist an employer in any competition in connection with safety and health, talks on safety and health, and any other activity which is held to promote a safety conduct of work at the place of work. 19. Rules on safety and health. 1. An employer of a place of work shall, in consultation with a safety and health committee, prepare and promote rules on safety and health which will ensure the safety and health of persons employed at the place of work for the guidance of such persons. 2. The rules may, with the approval of the employer, be amended, varied, or rescinded by the committee. 3. The employer of the place of work shall furnish to each of his employees a copy of the rules. 4. An occupational safety and health officer shall be given a copy of the rules when so requested. Number 20. Subcommittee. A safety and health committee may form a subcommittee to assist the committee in the perform of its function. Part 4. Meetings of Safety and Health Committee. Number 21. Frequency of meeting of committee. 1. A Safety and Health Committee shall meet at as often as may be necessary commensurate with the risk attendant on the nature of work at the place of work, but shall not meet less than once in 3 months. 2. Every member of the committee shall be given reasonable notice in writing of any meeting of the committee, together with a copy of the agenda for the meeting attached to such notice. 3. Notwithstanding sub-regulation 2, a meeting shall be called immediately in the event of an accident which result in loss of life or serious bodily injury to any person, a near-miss accident, a dangerous occurrence, or any other situation which call for immediate attention in order to ensure the safety and health of employees at the place of work. Number 22. Duty to provide facilities. An employer of a place of work shall: A. Provide a suitable place at the place of work for the Safety and Health Committee to hold its meeting, and B. Permits every member of the committee to attend such meetings during working hours. Number 23. Inaugural meeting. 1. An inaugural meeting of a safety and health committee shall be convened by the employer of the place of work. 2. At the inaugural meeting, the employer shall make known his safety and health policy, plans and proposal to establish a safety and healthy working condition at the place of work. 3. Say for sub-regulation 1, an employer may appoint his authorized manager to chair a meeting of the committee in his absence. Number 24. Quorum. At every meeting of a safety and health committee, the chairman, the secretary and not less than half of the remaining members present shall constitute a quorum. Number 25. Non-member may attend meeting. 1. A safety and health committee may invite any person who is involved in or has knowledge of any accident, near-miss accident, dangerous occurrence, occupational poisoning or occupational disease which has occurred at the place of work to attend any meeting of the committee during such incident shall be discussed. 2. The committee may invite any other person to any of its meetings to discuss any matter pertaining to occupational safety and health. Number 26. Matters to be discussed at meeting. Only matter relating to the safety and health at the place of work shall be discussed at any meeting of a safety and health committee. Number 27. Minutes of meeting. 1. A copy of the minutes of every meeting of a safety and health committee shall be furnished to every member of the committee and the employer of the place of work within 2 weeks after the meeting has taken place. 2. The employer shall keep a copy of the minutes of the meeting of the committee at the place of work for a minimum period of 7 years for purposes of inspection by an occupational safety and health officer. 3. An occupational safety and health officer may at any time require for a copy of such minutes to be furnished to him, and the employer of the place of work shall forthwith comply with such requirement. Part 5. Provisions of training and information. Number 28. Duty to ensure basic knowledge and functions of committee. An employer of place of work shall take such steps as necessary to ensure that members of the Safety and Health Committee have a basic understanding and knowledge of the function of the committee under the Act. Number 29. Duty to provide adequate training. An employer shall take such steps as are reasonably practicable to provide the members of a Safety and Health Committee with adequate training in occupational safety and health so as to enable them to perform the function of the committee effectively. Number 30. Duty to make available relevant document and information. An employer shall make available to a Safety and Health Committee the following document and information. A. The Act and all subsidiary legislation made under the Act. B. Industry codes of practice and guidelines relating to the elimination of risk to safety and health associated with nature of work carried out at place of work and such other relevant codes of practice. C. Information about safety plans and their implementation and any proposed change to the safety plans affecting the safety and health of employees. D. Technical information about safety and health hazards and precautions necessary to eliminate or minimize them. E. Information about operational procedures, system of work and substances for use at work and other relevant data pertaining to safety and health. And F. Any other information as directed by the Director General from time to time. Number 31. Information not to be supplied. Notwithstanding Regulation 30, an employer shall not make available to a Safety and Health Committee the following information. A. Any information the disclosure of which will be prejudicial to the interests of national security. B. Any information which he could not disclose without contravening a provision imposed by or under any written law. C. Any information relating specifically to an individual unless he has consent to its disclosure. D. Any information the disclosure of which will, for a reason other than its effect on health, safety or welfare at work, cause substantially injury to the employer's undertaking, or where the information was supplied to him by some other person to the undertaking or that person, or E. Any information obtained by the employer for the purpose of instituting, prosecuting or defending any legal proceedings. Part C. Penalty. Number 32. Penalty. A person who by any act or omission contravenes any of the provisions of this regulation shall be guilty of any offence and shall on conviction be liable to a fine not exceeding 5,000 ringgit or to imprisonment for a term not exceeding 6 months or to both.
Okay, now I would like to tell you more about Chapter 2, Safety and Health, and it is about the history of health and safety at work. Now let's go through the topics. So, the requirement a company to establish and documents needed is firstly safety and health policy, duties of the employers, employees, and the safety and health officers. Next, the Safety and Health Committee of companies, and the last one is Occupational Safety and Health Inspections and Offices. Now, let's go through with the first one is Safety and Health Policy. So, what is Safety and Health Policy? So, Safety and Health Policy is a written statement by the employer stating the company's commitment for the protection of the health and the safety of the employee, public, and the environment. This policy is endorsed by the management to its employee regarding their health and safety. Next, the second point, which is duties of the employer, employees, and the safety and health officers. So what are their duties regarding safety and health? So first of all, it is to ensuring the organizational activities comply with the regulation in the industry, carrying out risk assessment and identifying risk hazard, ensure the preventive measures, potential hazard, risk assessment and control to avoid hazard is implemented and used. So, developing occupational health and safety policies, manuals, and training. It is important to have policies, manuals, and trainings, and it is important to train the employees so that they know their own duties as a worker in a company. The next point is the Safety and Health Committee of companies. So it is very important to have a committee inside a companies because the main objectives of the committee is to foster cooperation and consultation between management and worker in identifying, evaluating, and controlling hazard at workplace. An effective channel of communication to exchange ideas to solve occupational safety and health problems, to enhance interest and motivation of all groups of management and workers at place of working safety and health. Next, the last point is occupational safety and health inspection and officers. It is very important to have an inspection in occupational safety and health because the employer are required to formulate safety and health policy at the workplace and regularly revise the policies to align the policies with changes and the best practice in the business work. It is important to avoid any kind of accidents or inappropriate manners in working without the safety and health inspections. So next is this comprise the initial, repeat and additional inspection of steam boiler, unfired pressure vessels, hoisting machinery, factories and installation and any other workplace. So it is very important to have inspection, especially in this kind of work because without inspection or a very repetitive inspection, it is very dangerous to have it in bad condition. So next is the investigation would be carried in the event of complaints, accident and occupational disease and poisoning. So this is the latest issue regarding safety and health. Everyone knows that this 2020 it is very vogue with news about COVID-19. So the latest issue regarding safety and health where the measure for protecting workers from exposure to the latest infectious virus COVID-19 depend on the type of work being performed and the exposure risk, including potential for interaction with people. So it is very important to have very safety and health precautions to avoid COVID-19 infectious virus so that the work can perform in the best environment and with best performance. So this is a video that shown about what OSHA says about COVID-19 and some of their method to prevent and avoid and steps to avoid COVID-19.
Hi, I'm Bernard Nomberg with the Nomberg Law Firm in Birmingham, Alabama, and I've had a few people call me in the last 10 days asking whether if COVID-19 or the coronavirus is discovered in the workplace, should OSHA be contacted? Should they do an investigation? Well, there's a few thoughts here that I want to go over, some of which are OSHA's requirements and some of their standards, and this is a little technical, but just keep this in mind as I go through this. OSHA does have recording workplace exposure issues and protocol in place dealing with COVID-19. Employers should record certain work-related injuries and illnesses on their OSHA 300 log for employers or people at the employment who are responsible for these types of things. They'll know what that log is. COVID-19 could be a recordable illness if a worker is infected as a result of performing their work-related duties. However, employers are only responsible for recording cases of COVID-19 if the following three things are met. 1, the case is confirmed that it is COVID-19, and under the CDC, the Centers for Disease Control and Prevention, they have a list of those descriptions for COVID-19 and how it gets investigated and those types of things. 2, the case is work-related as defined by the OSHA regulations. And 3, the case involves one or more of the general recording criteria that's also in those regulations. For example, medical treatment beyond first aid, days away from work, and those types of things. If you want more specific information, below I'll put the link to the OSHA website that gives those more in detail. The other thing to keep in mind are the various standards for OSHA's directives and how things should be when there is an exposure in the workplace, whether it's COVID-19 or something else. This covers all types of similar instances. OSHA does have requirements, not specifically for COVID-19, but for this type of situation or potential for preventing occupational exposure when dealing with the following. Among the most relevant criteria, OSHA addresses personal protective equipment standards, such as called PPE, and that's in the general industry when you should be having whether it's eyewear or masks or coverings over different parts of the body. There's also what's called a general duty clause under OSHA, which requires employers to furnish each worker employment and a place of employment which are free from recognized hazards that are causing or likely to cause death or serious harm. So those two criteria are general, but they would cover this type of situation dealing with COVID-19, coronavirus. Many states, over half of the states, also have their state regulations dealing with OSHA. So whatever particular state you're in, you may want to research whether your state has its local OSHA office and whether their standards meet the federal guidelines or maybe more stringent. Employers must also protect their workers from exposure to hazardous chemicals used for cleaning and disinfection. Now there is a whole another area of OSHA that deals with that type of chemical exposure or occupational exposure or hazards. Common sanitizers and things that used chemical-wise to clean surfaces also could be hazardous. There's many scenarios here. Don't overreact, but use your common sense when you feel that it could be or should be a recordable event. If you're an employee and there's that type of situation, first go through the chain of command at your employment. Hopefully they'll be responsive and reactive accordingly and get things taken care of. And if they don't, you always have the option to contact the Occupational Health and Safety OSHA administration. And again, I'll put their contact information below. I hope this provides a little bit of guidance. Every situation is different. If you have questions or concerns, just reach out to us at 205-930-6900. Our website is naumburglaw.com. If you liked this video, please give us a thumbs up and tell us why. And if you didn't, we want to hear about that too, because we're always striving to improve what we're doing around here. If you want to get future videos, just subscribe to our channel here. We're putting them out not daily, but weekly. We can also be found on Facebook and Twitter.
So, next is the general guidance for all workers and employers. This is very important where COVID-19 is getting harder in Malaysia, and with this general guidance for all workers and employers, they are requesting for a frequently wash hands with soap and water for at least 20 seconds with the running water, or use alcohol-based hand sanitizer with at least 70% alcohol. So it is important to avoid close contact with people who are sick, and it is important to avoid touching nose, eyes, or mouth with unwashed hand, because the virus may be contained in your hands if you are not wash your hands with soap at least 20 seconds. So if you feel sick or very uncomfortable with yourself, just stay at home if you are sick. Now I would like to tell further about the safety and health condition regarding the COVID-19 that has spreading around the world in 2020. So now I would like to tell about the interim of working guidance to all the workers and employers regarding this issue. So there is a few levels of risk for work in working, which is lower risk, medium risk, and even high risk. So for the lower risk, which is workers whose jobs do not require contact with people, or they can do works from home, or WSFH, working from home. So not frequent contact with people is very important to avoid contacting with patients that has affected with the COVID-19. Employers and workers in operation where there is no specific exposure hazard should remain aware of the evolving community transmission. Changes in community transmission may warrant additional precautions in some workplace or for some workers not currently highlighted in this guidance. Employers should monitor public health communication about COVID-19 recommendation and ensure that the workers have access to that information and elaborate with workers to design an effective means of communicating important COVID-19 information. So it is important for all the workers to work from home and avoid from meeting with people and cut off COVID-19 for wholesome. So next is the guidance where workers and employers of workers that increase risk of occupational exposure. So about this, certain workers are likely to perform job duties that involving them in medium, high or very high occupational exposure risk. Many critical sectors depend on these workers to continue their operation. So the examples of workers in this exposure risk group include of the frontliner, which is healthcare, emergency response and public safety, postmortem care, airline operation, retail operation, solid waste and wastewater management, environmental service, and of course in electrical source. So the travel to areas where the virus is spreading is also forbidden in the meantime of the RMO. Employer should assess the hazard to which their workers may be exposed, evaluate the risk of exposure, and select, implement, and ensure workers are controls to prevent exposure. Control measures may include a combination of engineering and administrative control, safe work practice, and also PPE. So, employers must identify and isolate suspected cases. In workplace where exposed to COVID-19 may occur, prompt identification and isolation of potentially infectious individual in a critical first step in protecting workers, visitors, and others at the worksite. Wherever feasible, immediately isolate individuals suspected of having COVID-19. For an example, move potentially infectious individual to isolation room on an aircraft. If possible and without compromising aviation safely, more potentially infectious individuals to sit away from passengers and crew. In other work sites, move potentially infectious individual to a location away from workers, customers, and other visitors, and with a closed door if possible. So after isolation, the next steps depend on the type of work. For example, if most types of workplace, which is outside of the healthcare, isolated individuals should leave the worksite as soon as possible. Depending on the severity of the isolated individual illness, he or she might be able to return home or seek medical care on his or her own, but some individuals may need emergency medical services. And if the isolation in healthcare workplace, if possible, isolate patients suspected of having COVID-19 separately from those with confirmed cases of the virus to to prevent further transmission, including the screening, triage, or healthcare facilities, restricted number of personnel entering isolation areas, including the room of patient with suspected or confirmed COVID-19. So sick workers should leave the worksite as soon as possible, depending on the severity of the isolated worker's illness. He or she might be able to return home or seek medical care on his or her own, but some individuals may need emergency medical services. Now I would like to present further about the safety and health topics, which is Occupational Safety and Health Act 1994, Act 514. So, in this topic, in this segment, we are going to acknowledge more further about the Occupational Safety and Health Act OSHA 1994. So, let's go through these sections. So in OSHA 1994, there will be 50 parts in the OSHA. So the first part is preliminary, appointment of officers, National Council for Occupational Safety and Health, general duties of employers and self-employed person, general duties of designers, manufacturers and suppliers, general duties of employees, safety and health organizations, notifications of accidents, dangers, occurrence, occupational poisoning and occupational disease and inquiry, prohibition against use of plant or substance, industry codes of practice, enforcement and investigation, liability for offences, appeals, regulation and miscellaneous. Now, in this part of the OSHA 1994, there will be a lot of information regarding safety and health during work. So let's go through one by one of the part. So the first part of the act is preliminary. So part 1, there will be 4 sections inside the preliminary, which is short title and application, prevailing laws, interpretation and object of the act. Next, there will be 3 sections in appointment of officers, which is appointment of officers, appointment of independent inspection body, and certificate of authorization. So there will be 7 parts regarding National Council for Occupational Safety and Health. It is important to have a National Council for this occupational safety and health because they can establish of the council. They can inside the section 9, where membership of the council can be presented, section schedule to apply, powers and functions of the council, appointment of secretary to the council, committees and annual report for the safety and health, which everything regarding safety and health. Next, part 4, where there is 4 sections regarding general duties of employers and self-employed person. It is important to employers or any self-employed person to have a general duties or general knowledge about the safety and health for their company, as shown in this act, where section 15 is the general duties of employers and self-employed person to their employees, duty to formulate safety and health policy, general duties of employers and self-employed person to persons other than their employees, and duties of an occupier of a place of work to persons other than his employees. It is important to have the duties of the employers and the self-employed person so that they can manage and control their duty accordingly based on their scope of job. Next part is part 5, where there is 4 sections regarding general duties of designers, manufacturers, and suppliers. So the section goes to section 20, where general duties of manufacturers, etc., as regards plant for use at work, general duties of manufacturers, etc., as regards substances for use at work, and section 22, where explanations to section 20 and 21, and there will be penalty for an offense under section 20 or 21 in section 23. So next part is part 4, where fourth section is regarding to general duties of employees. Earlier we have told about the sections that have insight of the general duties of the employer or the self-employed person, and this is now inside of the OSHA. There will be the general duties of employees, where it is in section 24 until section 27, which sounds like general duties of employees at work: duty not to interfere with or misuse things provide pursuant to certain provision, duty not to charge employees for things done or provided, and discrimination against employee. So it is important to have duties of employees and to keep their environment of working at the best situation and at the best working environment. So the next part is the safety and health organizations, where there are 4 sections regarding this topic. So it is the medical surveillance, safety and health officer, establishment of safety and health committee at place of work, functions of safety and health committee. So this section, where it is important to have at least a committee to have their environment with the best health of their officers and manpower. So next is part 8, where there are 3 sections regarding notification of accidents, dangerous occurrence, occupational poisoning, and occupational disease and inquiry. So it started with section 32, where notification of accidents, dangerous occurrence, occupational poisoning, and occupational disease and inquiry. Director General may direct inquiry to be held. Power of occupational safety and health officer at inquiry. So this is important, where OSHA has safety and health about this notification accident, as the workers or employees or even the employers themselves have to be aware of any notifications regarding accidents to ensure or to avoid any further accidents that can cause losses for their company or losses to their manpower. Next is part 9, where prohibition against use of plant or substance, where there are 2 sections in this part, which is power to prohibit the use of plant or substance, or aggrieved person may appeal. Next is part 10, industry codes of practice, where there are 2 sections, which is section 37 and 38 regarding this topic, which is approval of industry codes of practice or the use of industry codes of practice in proceedings. It is important to have an industry codes of practice inside a company to actually use these codes among them, so that it is a best practice to have a very smooth working conditions. Part 11, where there is 12 sections inside this part, where it is regarding to the enforcement and investigation. It is started with section 39, which is powers of entry, inspection, examination, seizure, etc. Entry into premises with search warrant and power of seizure, entry into premises without search warrant and power of seizure, power of forceful entry and service on occupier of signed copy of list of things seized from premises, further provision in relation to inspection, power investigation, power to examine witnesses, employer as a taught to assist officer, offences in relation to inspection, improvement notice and prohibition, notice, penalty to failure to comply with notice, aggrieved person may appeal. So in this part of the OSHA, they stated about how examination or any investigation is held to gain and their actions if there is no warrant, if there is a warrant or anything with the power of the seizure. Okay, next. Is part 12, where there are also 12 sections starting with section 51 regarding liability for offences. This liability for offences also regarding to some company that will related to the court or anything that has been happened in their company that has in needed of liability for offences. So the sections are discussed as general penalty, offences committed by body corporate, offences committed by trade union, offences committed by agent, defense, body corporate or trade union liable, aiding and abetting, safeguards against further personal liability, civil liability not affected by parts 5, 4, and 6, section 60, where honest of proving limits of what is practicable, prosecution, compounding of offences. So next is part 13, where there are 3 sections regarding appeals, where the appeal committees, power of appeal committee and decision of appeal committees. This part is also regarding of any issues that relate to court, where they have to attend any court session to discuss further about their issue. Part 14, where regulations is stated, where and regulation according safety and health regulations in section 66. And last but not least, this is section 67, where part 15 miscellaneous, which is the duty to keep secret. So it is important to keep a secret regarding their issue of the company and not to bring anything outside from the range of their company has been selected. Okay. So this all 15 is the Act of 514 OSHA 1994, which is Occupational Safety and Health Act.
Hi, this is Katrina, and she'll be demonstrating the donning procedure for coronavirus. First, do hand hygiene using hand sanitizer or soap and water for a full 15 seconds. Next, don your gown, fully covering your torso from neck to knees, arms to end of wrists, and wrap around in the back. Tie the gown at the back of the waist. Next, don your mask or PAPR. You may use a procedural mask or an N95. For the procedural mask, place the ear loops behind your ears. Make sure the bottom of the mask is hooked under your chin and above your nose, and smooth the top across the bridge of your nose. Don't pinch. For the N95 mask, place the mask on your face, covering your nose and mouth. Pull the bottom strap up and over the top of your head, and place it behind your head below your ears. Then take the upper strap and put it behind your head toward the crown. Mold the nose piece of the mask over the bridge of your nose to obtain a tight seal. Perform a quick fit check to ensure there is a good seal against the skin. After securing your mask, place your eye protection over your face and eyes and adjust to fit. When donning your gloves, extend to cover wrist of the isolation gown. Upon completion, eye protection should be over your face and eyes and adjusted to fit. Your mask should be covering your nose and mouth with a tight-fitting seal. Gown should be covering from neck to knees and tied in the back. Gloves should extend to cover the wrists of the isolation gown.